Hi. I'm about to read chapter 15 of Hotsy Feminazi, Fraud Upon the Court, and I find that this is a chapter that people have a tough time wrapping their head around. There are things that are reality, and one reality is whoever has the power is calling the shots regardless of the truth and regardless of law. If you're confronted by someone with a gun, they have the power to perhaps make you do something or say something that you wouldn't normally say or do. You would pretend that something might be true to appease the person who has the power. Power has nothing to do with truth, and power has nothing to do with laws. There are three separate things. What I'm a victim of is power. I have the truth on my side, I have the law on my side, but the law and the truth have been disregarded by a court that holds power. People out in the world, banks, the government, the police, will do something that a judge tells them to do regardless of if he or she is right or wrong. This is improper, this is wrong, but this is the world we live in. I'll read the first part of the chapter, and the second part is the actual litigation, which if you want to read, you can read, but it's not important because I describe it before I actually print it. I just put it in so you could see the actual litigation. So here we go. I'm going to read chapter 15, Fraud Upon the Court. The first sentence is shocking, and people they don't really want to get it, but if they think about it and they're honest, they get it. So here we go. As it turns out, as of the time of this writing and the time of recording this video, Stacie and I are not divorced. The U.S. Supreme Court has held that a void order is void at all times, cannot be made valid by any judge, nor does it gain validity by the passage of time. The order is void, ab initio. Ab initio means when it's initiated. Why the court uses Latin is something for another video. I find it very stupid. And that's according to Valley or Valley versus Northern Fire and Marine Company, 254 U.S. 384, 1920. Then, no court has the lawful authority to validate a void order. This is by authority of U.S. versus Throckmorton, 98 U.S. 61, 1878. All orders based on void orders are themselves void. Austin versus Smith, 312, blah, blah, blah. 1962. If the underlying judgment is void, the judgment based on it is also void. In other words, if the order is based on lies, the order is void. My divorce order was based on lies. It only takes proof of one lie to void an order. Here is the true list of the claims upon which the judgment against me was made. Annual income of $60,000 attributed to Fred. False income of $60,000 set forth in March 9, 1999 judgment. True income of $20,004.97, $25,515 for 1998, based on the actual Social Security statement, which you saw in the last chapter, which is attached as Exhibit 1 to Fred's declaration. I told the truth. Weekly payments of $300 alimony and $263 child support. False weekly payments of $300 alimony and $263 child support set forth in March 9th, 1999 judgment. In other words, the order was made on a false amount. The true payment amount, $433 per month, was independently established by the Los Angeles County District Attorney's Office in March of 1999, as showed in Fred's declaration. The false payments of $563 exceed Fred's weekly gross income by $52.32. So understand, the judge ordered me to pay more than I made. His order was based upon fraud. Next is the value of family residence. I bought the house for $190,000. Years later, the court valued it, or Lori Bernstein valued it, or Stacie valued it, because it certainly wasn't me. They valued the house at $175,000. This house, by the way, in later years sold for $480 some odd thousand, okay? So that was a fraud. Vitiates the order. The order's void. Void. The divorce order is void. Stacie and I are still married. Next, value of Harley-Davidson motorcycle. We went over this in a previous chapter. Value in the March 9th, 1999 judgment was $12,000. True value, based on my declaration, was $8,000. The false value was a lie. It was a fraud perpetrated upon the court. The divorce order is void. Stacie and I are still married. Possession of $10,000 of tools. Stacie took possession from A&E Hauling, as shown in March 9th, 1999 judgment. All tools were located at A&E Hauling, as shown in Fred's declaration. Therefore, the value of tools in Stacie possession was $10,000, not $750 as claimed in the March 9th, 1999 judgment. The time has come to clean up the mess of the void and fraudulent January 12, 1999 contempt order and March 9th, 1999 default final judgment divorce. Stacie has been paid $41,688 through wage garnishment of the LA District Attorney's Office instituted by Fred and his voluntary payments. She also confiscated $16,879 from Fred's Roth IRA in 2006, which was funded with his share of his after-divorce income. This action goes to prove to Fred, as stated by Interstate Collection Service, that he will never be able to prepare for his own retirement. Additionally, she had taken the entirety of $36,000 of Fred's share of the equity in the family residence. She stole my half of the equity, and she stole my IRA, which was funded with after-divorce money. The list above is why fraud upon the court voids my divorce order and is the reason that Stacie and I are not divorced. Below is the actual motion from January 27, 2010, which you can read if you have the stamina for legalese. And then the rest of the chapter is the actual document. Now, this is really a serious situation. And I have told the truth here. The divorce order is void because it is based on fraud. Now, the court will violate the law. Stacie will violate the law. Everybody connected with this case will violate the law because a judge who has the power to make them do these things will make them do these things. But he will still be wrong. He will still violate the law. The court will still be in violation of the law. And in addition to that, they are all dishonest. And that is the straight story. Thank you for listening. I hope I've made this clear. Now, at this point, the rest of the chapter is the actual motion, and if you want to read the legalese, you can, but I'd like to spare you that. But the first part is important because there are more frauds. So here we go. I won't read the whole thing, but here we go. To all parties and their attorney of record, please take notice that plaintiff John Fred Stacie, hereinafter Fred, hereby moves to set aside as void the January 12, 1999 contempt order and March 9th, 1999 default judgment of divorce as void for fraud upon the court, except those paragraphs granting the divorce and granting defendant Stacie Gray Stacie, Stacie, her maiden name of Stacie Ann Gray. Each of the documents was drafted by Stacie Ann Gray and Gray's attorney, Lori A. Bernstein. Now, let me make this clear before I continue. I didn't want to stop the divorce, and I don't want to stop the divorce now. And I certainly want Stacie to be able to use her name, Stacie Gray. It's not the point of this. But because this order is void and Stacie and I are still married, if she has remarried, she is now technically a bigamist. Any action taken against me after the time of the void order, and all actions must be taken by her. She's under the impression, perhaps, that the state does these things, but the state cannot do these things without her authorization. So she is actually still in the driver's seat when it comes to all of this. I don't want to appear harsh. I'm just telling the truth, and I'm telling you what the law is. Now, the reason for this motion are as follows. John Fred Stacie was not served with an order to show cause regarding contempt, nor was he arrested in order to appear at the December 17th, 1998 hearing. Now, if you read the divorce, part of the divorce is based on this, and it can't be. Fred was not served with a notice of deposition, nor did he fail to answer the questions after ordered to do so at a deposition. The January 12, 1999 contempt of court order against Fred, and remember, this is January 12, 1999, my divorce wasn't until February. The January 12, 1999 contempt of court order against Fred was void because the court did not have jurisdiction to enter such, as no contempt occurred in the presence of the court as required by Rule 110-1. The court did not issue an order for arrest or an order to show cause specifying the acts or omissions alleged to have been contemptuous as required by Rule 110-2. A motion for enforcement of litigants' rights, which was the basis of the December 17, 1998 hearing, is not a contempt hearing if all parties agree under Rule 110-3. And the remedies under Rule 423-2, failure to be sworn or answer a question or permit discovery after ordered to do so, and 423-4, failure of party to attend his own deposition after proper notice, do not apply in this case, as there was not an issue of Fred not attending a deposition, failing to be sworn, answering a question, or providing discovery after being ordered to do so. There is not any record of Fred violating any discovery order, including attendance at depositions or answering questions. The dismissing of Fred's complaint and the answering of his answer and affirmative defenses to the counterclaim under Rule 423-2 and entering a default and ordering attorney's fees under Rule 423-4 in the January 12, 1999 order was void. Lori A. Bernstein knew or should have known that the January 12, 1999 contempt order was void when she drafted it and presented it to the court. By giving the court a draft order containing substantive parts that they knew or should have known violated court rules and were void, Stacie Ann Gray and her lawyer, Lori A. Bernstein, committed a fraud upon the court to sign a void January 12, 1999 contempt order. Now, we procured a copy of the court file. We examined every single document in the court file. The court has no documents stating that I was in contempt of court or that I violated a deposition or any such thing. That's right from the court file. The U.S. Supreme Court has held that a void order is void at all times, cannot be made valid by any judge, nor does it gain validity by the passage of time. The order is void ab initio, and now you know the rest. I mean, I've said this all, and so not only are the terms of the divorce void, but everything leading up to it is void. Lori Bernstein committed fraud against the court. She is a lawyer. This is a very, very serious crime. For a lawyer to do that, it's perjurious, and I'm just running through the document to make sure I haven't missed anything. When I came to LA, I gave them copies of everything. The court here established an amount of $433, which was taken right out of my pay, so I was never late or in default or anything like that, up until the court came to another decision later, in which case I didn't have to provide any money. So in LA, they seem to have it figured out. In New Jersey, they abused their power, they denied the law, they denied the truth, and are guilty of the violation of my civil rights. Now, this is not in the book, but I would like to add the fact that back in 1999, Judge James Convery did allow all this despite the fact that I made the truth clear. I didn't appreciate all this at the time. I was innocent. Having learned about fraud upon the court, I did present all this and much, much more in multiple appeals in 2010 and 2011 to Judge Triano. This Judge Triano knowingly denied my appeals. In fact, the first time he denied it, he said that I didn't bring anything new to the case. I sent then an appeal to him with pages and pages of underlined information about more and more fraud and more reasons why. He then denied all this. So, as I say that my civil rights were violated, my civil rights were not only violated in the first case, but my civil rights violations were then again reinforced by another judge, this Judge Triano, who knew in no uncertain terms what had happened, how it had happened, when, by whom, and what. He could have remedied this situation at that time easily. Remember, I'm not trying to void the actual divorce. I'm not trying to force Stacie to use her married name, or I'm not trying to interfere with any current relationships she may have or any of her current finances. I'm asking for nothing. In reality, what I'm asking for is the original order to be void and a new and reasonable order to be created. I made this very clear in multiple appeals, which were very disrespectfully turned down. So the civil rights violation goes from what could have been a mistake or an anomaly or a misunderstanding or whatever to an actual conspiracy. And it's this conspiracy that I feel is a prime example of hundreds of thousands, maybe millions of similar circumstances that have happened to an uncountable amount of men and even probably a couple of women here and there. So this is how serious the crime is. It's a crime against me, certainly, but it is a civil rights issue, and it should be taken very, very seriously as such.